Good morning. My name is Carl David Birman. I'm an appellate attorney here in Schenectady, New York. I can be reached on area code 518-952-0516. And on today's video blog, my guest is Chaim Steinberger, a Manhattan attorney. Chaim, could you introduce yourself, please?
Hi, good morning. Chaim Steinberger at Midtown Manhattan. I am a divorce and family law lawyer. My website is manhattan-law.com, and my phone number is 212-964-6100. And it's my great pleasure to be here with you, Carl, because of your extensive experience in family court and my experience in Supreme Court. And so I think we make a great pair to be able to discuss these very important issues for litigants.
Thank you, and I hope our video blog audience agrees. And if you do like today's conversation, please make sure to click the like button, follow me on social media, and share it with anyone that you think might be benefited by listening to this conversation. Today, Chaim and I have decided to discuss two interrelated topics. Number one is how to litigate in family court. And of course, a discussion like that would be beneficial to a colleague attorney, so welcome other attorneys if you're listening, but certainly people who go to family court want to know how it's done. So even if you're not an attorney but a litigant, it would be beneficial for you to learn a little bit of the nuts and bolts of how litigation occurs in family court. And Chaim also proposed an interrelated topic, which is how judges decide cases in family court. So Chaim, you just paid me an enormous compliment that I'm knowledgeable about the ins and outs of family court, but I'd like to hear your thoughts first, and then I could respond on these two interrelated questions of how you litigate a case in family court. And let's break it out because there are all sorts of different cases that come up in family court. Let's talk about the one that most people come in the door of a family court building for, and that would be child custody, child visitation, parental access, and parenting time. So Chaim, what are your thoughts about how to litigate a matter in a family court in New York State regarding those topics?
So I'm going to start with general propositions. Many people make the mistake. This is in fact a rookie lawyer's mistake. And the phrase I keep using over and over again in my lectures and in my writings is the practice of law is not arithmetic. Too many people think that, oh, 2 + 2 is 4. And so people sometimes come to me and say, Chaim, you're a great lawyer, but you're very expensive. I've got this kid, next door neighbor. He just graduated law school. I'll let you decide the strategy, and then we'll give it to the kid to come into court. And what they don't get is that litigating is more like a game of chess than it is arithmetic. And so 2 + 2 might be 4, up, down, right, left. It doesn't make a difference. That's the way it goes. But you can't pipe up in court and go, 2 + 2, Your Honor. And the judge goes 4, of course. The timing can be crucial. When you say it, if you make the same chess move, one move too soon or one move too late, it can cost you the game. If you make it at the right time, it gives you the whole game. So number one, it's not arithmetic. What every litigant in any type of case has to do is you have to win over the judge's heart, mind, body, and soul. The judge has to be absolutely convinced that if the judge doesn't do what I want the judge to do, that a grave injustice is going to be done. Let's start with the proposition that judges, as a general matter, try to do the right thing. It is my job as an educator to teach the judge what the judge needs to do in my case. It's my adversary's job to teach the judge what to do so that the judge makes their right decision. And that's one of the reasons that representing yourself, we lawyers have a saying, any lawyer who represents himself has a fool for a client. And that's because you can't do both. When you're sitting, there's a phrase in the Talmud that goes, no prisoner can release themselves. Even if I'm the greatest breakout artist and I can release somebody else from jail, I can't release myself from jail. When you yourself as a litigant, you don't have the same moral persuasive authority to tell the judge. I can tell the judge that my client is a good person, and it rings differently than if the client themselves says that they're a good person. So
okay, I got to jump in here and throw in my 2 cents, if you don't mind. May I? So I've practiced in a lot of courts in different counties, going out as far as Nassau County on Long Island, and now I'm up in Schenectady County in the outer reaches of the Capital District near Albany. And I've seen that perspective, but I've also seen the exact opposite. I've seen judges take cases involving custody and visitation where the parties both come in and they don't have lawyers. And the judges are literally trying to avoid bringing in counsel. They have referees, they have magistrates in some cases. They also have judges who spend an inordinate amount of time with litigants who are pro se, meaning they've not uh, hired counsel, nor have they been assigned attorneys. And the judges try and work these cases out. And it astonishes me how much can go on behind those closed doors, where you have two parents sitting at two tables and you have a judge in a robe. This is an elected family court judge spending time out of their busy day trying to finesse and finagle and negotiate and see if 5 plus 5 really does equal 10, or maybe can we make it in this case a little bit closer to 9? Can we avoid blowing up the situation? Can we avoid the scenario of throwing out the baby with the bathwater? And I'm not disagreeing with you, Chaim. I think that lots and lots of these problems do require the judge to have uh, his or her heart, body, mind, and soul engaged. But I'm also concerned that when a lawyer comes in full throttle like that, and the other side might have either no lawyer or a lawyer who just happens to be a local practitioner who is not as fired up about this particular case, that now you've taken it to nuclear stage. Or as my trusty real estate banker said when I was planning to buy my house, DEFCON 3. And in my experience, having done family court custody litigation for about 17 years, 16 and a half years now, I'm not sure that that always really helps. Very often, particularly when people were not married to begin with, there are bitter, intense, hardcore feelings. And there's a catharsis that has not happened. And there's bitterness and hatred. It kind of reminds me what a brilliant, brilliant judge in White Plains Family Court told me 10 years ago. He said, Mr. Birman, the opposite of love is not hate. And I had a client there who was very angry at his ex. And I said, Judge, well, first of all, the clients were not in the courtroom. This was an attorney's conference. He said, the opposite of love is indifference. And until your client reaches the point where he's indifferent to her particular moods, her particular accusations against him, and she doesn't enrage him every time she opens her mouth, we're not going to resolve this. And I thought that was almost kind of a Buddhist insight about how to look at child custody litigation, because litigation is not always the be all and end all of these cases. And I think that I'm worth my rate, my hourly rate, and that my retainers are well spent. And I know that Chaim's are, otherwise I would not have invited you to join me today, Chaim, on my video blog. But I also think that common sense sometimes can dictate a slightly different approach to litigating, which is not to say that we just go crazy and we file motions nonstop, but that we have a little bit of balance and perspective about what we are doing as lawyers and judges in this process.
So I agree with everything you've said, Carl, and perhaps I didn't make myself as clear as I should have. So number one, I think you know this about me, that I've been mediating disputes for 25 years. I'm proudest of the fact that sometimes I come into bitterly. Now I'm a bulldog advocate when I need to be. No, let me back up. There's so many threads here that I'm almost apoplectic about which one to run after and chase first, to carry the bulldog metaphor even further than it was intended. So number one, unfortunately, we have colleagues that are terrible for the system, terrible for the parents. All they know to do is to come in and, shall we say, spray lighter fluid all over the embers, and let's make back when I worked for a preeminent matrimonial lawyer, and I was thinking of taking a job somewhere, and he said, don't go work for her. She's like a junkyard bulldog. And I say, what do you mean? First thing she does whenever she comes into cases, fire off this nasty letter full of diatribes, so that if there was any possibility of the people getting back together or settling this, that's out the window. And now everybody's inflamed, and now we go fighting. So I'm not advocating that at all. And I agree with you that just because I believe in the justice of my client's case doesn't mean I always have to speak with as much vehemence as I did here this morning. There is, so my great mentor, so I've been collecting best books for the last 30 years. The best book I've ever found on litigating is written by the late Judge Ralph Adam Fine, The How to Win Trial Manual. And he quotes
How to do what?
The How to Win Trial Manual.
Right.
Fantastic book. Not cheap, but a fantastic book. And he talks about legal jujitsu, which is how to take your weakness and turn it into strength, how to take your opponent's strength and turn it into a weakness. But he talks about a study of placebos. And it turns out that when dentists gave patients a placebo for their pain, right? And you know, obviously, placebos, it turns out that the most determinative factor on whether the placebo would reduce the patient's pain was whether the dentist believed that it was a real painkiller. Somehow, if the dentist knew it was a placebo, even without telling the patients picked up on it, and then it didn't reduce the pain. And if the doctor believed it was a painkiller, now I have questions. I don't think that study could be done now today, because if it was, that seems to violate the doctor's knowledge of knowing what they're giving. But in any event, but the point is there that a client who doesn't see the justice in his client's case, a lawyer who doesn't believe in the justice of his client's case is going to lose that case. Now, what approach, what tack I take in getting that, maybe I need to be fired up, maybe I don't. And that depends on how we do it. But I agree with you that you don't come in barnstorming in every case. And I can see how judges think. I know a lot of mediators. Whenever I mediate a dispute, I want the parties to have lawyers in the room, because if the party doesn't have a lawyer, the party can make a misstep. Who's going to protect that party? As a mediator, I'm not supposed to leave the seat of the neutral. And if a party's about to make a misstep and I warn them off, the other side knows I've now become a partisan. So I want the lawyers in the room, whereas most mediators say, no, lawyers destroy mediations. And I'm like, why would they destroy mediations? You want to satisfy them if you listen to them, if you let them express. So I'm of the belief that lawyers add to the process. I know that it's not a universal belief, and it's certainly not true for all lawyers. There are the lawyers that are just obstructionists for the sake of obstructionism. And that's not what I'm talking about. And I agree with you that we have to not only, well, we certainly have to listen to our clients' instructions, but in our roles as counselors, we should be telling our clients that more important than what we do here today is their ability to co-parent the children for the next 20 or 30 years. People think the fight doesn't end when the children turn 18 or 21. If mom and dad both make their Thanksgiving Day meals at exactly the same time, the kids are pulling their hair out when they're 31 years old. And they're like, do we go to mom and dad gets angry? Do we go to dad and mom gets angry? You know what? Screw them both. We're not going to either one of them. Yeah. The greatest gift parents can give a child is the gift to be able to love the other parent too. So the question becomes, and I speak about this in my program on divorce without destruction, how do I, but this is sort of on my side of the behind the wall, how can I make, let me back up a second. Most people fight viciously because they're really scared. If I can give my client the safety of knowing they're going to get a good result, now they can take that deep breath. They can let go of the fear. Fear usually gets turned into anger, because anger is a very powerful emotion, and it can take you. Fear is very difficult to deal with. And so fear gets turned to anger. When that judge says the parties have to get over their anger, how can we as lawyers help them? The answer is by helping them feel safe. And if I can make my client feel safe, if somehow I can communicate this through the other lawyer to the other party, that I'm a tough litigator, but I won't take unfair advantage of them, then now the temperatures can cool down. And I've had luck settling even the unsettleable cases, even in litigation.
We've talked about mediation. We've talked about the role of settlement and being fair and reasonable. And there's no right or wrong answers. There's no specific roadmap. And as you said, it's not arithmetic. It's probably calculus. It's quite complicated. We've talked about our first topic a little bit, how to litigate in family court. Number two, and I want to throw in a curve here, and I'm sure, Chaim, you're going to jump off this and go in your direction, which I'm sure will enlighten us. How do judges decide? And we're just staying within the confines of family court. People have to understand, and this takes a while to unpack. So, because we have a lay audience here, family court often hears cases involving child custody, even if the parties were never married. In fact, typically that is sort of the bailiwick of family court, is cases where parties are never married. And I've had cases in front of judges, just like that judge who I quoted before, saying that the parties need to get over their anger. Tell me the following: Mr. Birman, I see you have an objection that this seems unjust to you, and you feel that this ruling I'm making or this step I'm proposing to take violates this rule and this procedure and this fundamental due process right. But Mr. Birman, what you're forgetting is that family court is a court of best interests. Well, that shut me up for a long time. And in fact, ironically, it was the same judge who I sure will not be watching this program, but out of my love for the bench, because I do have, proud to say that I have not personal friends, but I have judges that I admire. And we all know how the internet spreads things along, but I'm not going to mention this judge's name. So I said to myself, wow, family court is a court of best interest. Now you have to understand, Chaim and I both went to good law schools. So this raises a fundamental philosophical question about the authority of a court. We were all taught, in fact, the exact opposite. Family court is a limited court of limited jurisdiction. It only has the power that is enumerated in the statute. It is not an equitable court. It is not a court of equity. When you talk about best interest of the child, my God, you're opening up this sandbox here where a court potentially could have all sorts of powers. What he was really trying to say, that judge, in an inartful way, because we all think we know it's in the children's best interest, is that the judge is stepping into the role of a parent. So there's an old case, I can't recite off the top of my head, Chaim, maybe you remember it, where the phrase was in locus parentis. The job of the judge is to be a parent where the parents are incapable of doing what normal parents do in a collaborative parenting arrangement. And by taking on that role, and the parties have given the judge the power to be a parent, the judge is bringing in his or her biases, personal experiences, knowledge as a parent or as a grandparent or as an uncle, and so on and so forth, and their feelings and their attitudes, all of which are very, very subjective. So coming to this theme today, how do judges decide? The answer is it's complicated. They're human. They try their best. But when it comes to something like the best interest of the child, you know, the devil is in the details. So Chaim, your thoughts.
You're pretty much, you're confirming what I said. You're saying it in different words. So, and all of this is true. And the sophisticated view is to recognize how all of these concepts interleave with each other. So number one, family courts are in fact statutory courts of limited jurisdiction. They're not courts of equity. They cannot decide contract cases. So if you and your partner have a contract that you will do such and such, you can't go into family court and expect them to enforce it. They can't do it. They only have limited jurisdiction for custody, child support, abuse and neglect, and what we used to call truancy. So they are. However, within each of these categories, so when we talk about custody, the best interest is how you decide custody. Now, I may have mentioned this to you, Carl, in one of our previous discussions. I had a profound conversation with a judge I was friendly with in one of my first trials. I was trying a case in front of the Supreme Court in Kings County, and I met this judge at a bar association event, and he says, "So, Chaim, how's your trial in front of Judge so-and-so going?" And I'm like, "Oh, it's terrible." And he looks at me, he goes, "What do you mean? Why is it terrible?" And I think for a moment, how do I frame this in a way that's fair to the judge hearing the case, but fair to me? And I look at my friend, the judge, and I say, because the judge is trying to do what he thinks is right instead of following the law. And this judge was taken aback, and he tells me, judges are never supposed to follow the law. They're always supposed to do what they think is right. Now, this was such profound advice. But it's more nuanced. It's not a blanket statement. It's not judges have complete authority, but we live in a common law system. And a common law system means that judges build on cases before them.
Give me 1 second.
And we can do a whole program on common law and what that means and what are the limits of judges' discretion. But fundamentally, people don't want to do, we know in criminal law, for example, there's a concept that we don't tell juries about, but jurors have the right of jury nullification. If we prosecute somebody for drafting the Vietnam War, their juries were able to come back and say, we find him not guilty, even though we know the defendant did exactly what he was accused of doing. The jury has a right to say, we're still not going to hold him guilty. And so the judges try to do what they think is right. The law sort of bounds what they can and do. I, as an advocate, need to give the judge the law and show the judge how the judge has the authority. I use the law to permit the judge to do what I want the judge to do. But the motivation comes by winning over the judge's heart. Your Honor, this child needs to be the safety of the child, the well-being of the child. And this is the right thing to do in this case because. And so it's that emotional hook that becomes so important. And it's a rookie mistake to get up and say, Judge, I know what I'm doing doesn't really make sense, but the law requires you to do it. Judges are going to avoid those types of results 99 times out of 100.
So I wanted to that was great. I just wanted to pick up on one thread, which was the idea that a family court judge hearing a custody dispute under Article 6 of the Family Court Act doesn't want to get into the weeds of other disputes that the parties might have, which was pretty much what you tried to say. But you referenced the idea that perhaps in addition to having a baby together, these people had a contract to do some kind of business or sell or purchase some item between the two of them. And family court really can't get involved in that because family court has whatever authority the legislature gave it. But the real question that most people would hear that to raise is, well, what if we had an agreement outside of court? We didn't go to a mediator, Your Honor, but when the baby was born, we were already on our way to Splitsville. So we sat down there in the hospital when we got home and we wrote, I, the mom, agree that you, the dad, shall have alternate weekends until our child reaches the age of 18. And you, the dad, agree to pay child support up to and including college tuition, except if it's Harvard and except if it's without a full scholarship, then you understand that might be too expensive. Now, that's a fascinating piece of paper. And I have had people present pieces of paper like that to me, especially when the mother or the father is no longer available to come to court because that parent might be in jail or might have left the state, the jurisdiction, and so on and so forth. The question is, what does family court do with a piece of paper like that? And it comes back to what that judge said, that in some ways, family court really is a court of best interest. The job of a family court judge is to find out what is in that child's best interest today, not when that agreement was signed, if it was an agreement, if it was executed without duress and with people having full knowledge and there was no coercion. But that piece of paper at best is just going to be a little shred of evidence, an exhibit to suggest that at the time, the parties were thinking in this certain direction. There are no contracts that family court will enforce as to custody, visitation, parenting time, and access. What there are states of mind, states of being, and all sorts of shreds of evidence which can point in one direction or the other. But ultimately, the judges have to decide cases as they see fit, which isn't, may I add one more thing, or you want to respond? You should respond.
Well, there's actually a split between the first department and the second department on a very closely related issue. So as you and I both know,
People
well, you're in the third department.
Hold on, people may not know what the first and second department.
I was about to explain it. So New York State is split into 4 appellate division departments. The first department covers only Manhattan and the Bronx. Second department covers Brooklyn, Queens, Staten Island, Nassau, Suffolk, Westchester, Rockland, maybe Orange. Okay.
Dutchess, you forgot.
And Dutchess.
And Orange.
The third department covers sort of the Albany region where you're at, all the way up to Canada. The fourth department is further west, the Buffalo region,
right,
and all of that. And sometimes the appellate divisions have they rule differently, and trial courts in the first department have to follow first department precedent and first department declarations. Courts in the third department have to follow third department. And until our highest court, the New York State Court of Appeals, decides a case and the departments can split up. There's a little known rule. Many lawyers don't know this. If I'm in the second department and a fourth department makes a decision under Mountain View Coach, I think it is, my trial court judge must listen, must abide the fourth department precedent unless the second department has said something different. Second department hasn't spoken to the issue. My trial court has to follow the fourth department because we have a unified court system. But forgive me, I run into the esoteric. In any event, the question pops up, particularly in religious people, where they sign a deal, perhaps a separation agreement, or perhaps when they get married, and they agree that they will submit any dispute they have, including custody and visitation, to a rabbinical court. And so the question becomes, will a court enforce such an agreement by the parents to go to rabbis to decide the custody of the children? And so there's a split. Last time I checked, which hasn't been for a while, there was a split between the first department and the second department. The second department, an opinion by Justice Sunshine, who's now the chief administrative judge for matrimonial matters statewide, wrote that because the courts serve as parens patriae, which means the uber parent for those persons who can't represent themselves, who can't protect themselves. So the courts step in as a parent of these vulnerable children. And Justice Sunshine writes that because, and it's of course a second department case, and Judge Sunshine is not on the second department, he's a trial level judge. The second department says that because the courts are parens patriae, we don't care what the parents have said about it. It's our job to determine what is in the best interests of the children. First department says, wait, I know that we get to decide, but if the parents agree to go to the rabbinical court to decide, we'll send them, we'll compel them now. I mean, the way these cases come up is that now that they're splitting up, one parent says, no, I don't want to go to the rabbis, I want the court to decide. In the first department in Manhattan and the Bronx, the parents are compelled to first go to rabbinical court, litigate their case in front of the rabbinical court, and then when the rabbinical court makes its decision, they take it back to the judge in the state Supreme Court. And then I haven't seen what level of review, whether state Supreme Court is required to give deference to the rabbis. I imagine that they wouldn't have to, and the judge makes his decision anew. And if the judge makes a decision anew, why did we force these people to go through the litigation process? But in any event, there's that split. So, which means that although parents can make a decision, although parents can sign a piece of paper, now, we all know that in the Domestic Relations Law 236b3 says that for an agreement to be enforceable in the area of divorce, and I'm not quite sure, I imagine it will, well, let me not say, I haven't seen any case law on whether it applies to a custody visitation dispute where the parents weren't married. But for an agreement to apply in divorce, it has to be signed and it has to be notarized at the time and acknowledged, which is even more than notarization. This is a requirement that applies to real estate deeds. There has to be an acknowledgement, and the acknowledgement has to be done at the time of signature. And without that, it's not valid. However, a skillful litigator would put the other party on the stand and go, Mr. Smith, a year ago, you agreed that Mrs. Smith should get the custody of those children. And he has to say, well, yes, I agreed. And you signed this paper, yes. And you knew what you were signing, yes. And at the time, you thought that that was best for the children. And now what's he going to say? He can't say, I signed an agreement knowing it was going to be harmful to my children. And so he has to admit that at that time, he believed it was best for his children. And so, of course, he's got a higher mountain to climb in order to get custody back. And people sometimes don't realize this. I've had people call me and say, well, I signed the agreement, but it wasn't notarized. And so I'm going to go in and go. It's like, okay, and sir, how are you going to deal with it? Why? What has changed since you signed the agreement? That becomes a very powerful piece of evidence that even the father thought that mom is a better custodial parent, or even the mother thought that dad was a better custodial parent. And therefore, it may put its finger on the weight on the scales of justice, and it may be a burden that's too high to overcome for the other parent.
This has been unbelievably enjoyable. Chaim, we're at about the 30 to 35-minute mark in our interview, chat, discussion, dialogue. It's not been a debate because we found so much common ground on our topics today. My name is Carl David Birman. If you joined us late, you just clicked forward and you missed the intro. I'm an appellate attorney based in Schenectady, New York. I can be reached at 518-952-0516. My email address is also posted on the description for this video. My guest today, Chaim Steinberger, is a Manhattan matrimonial attorney who also does plenty of family law work in family court. And Chaim, what's your phone number again, please?
212-964-6100. 212.
And Chaim gave his website. I imagine this video will be on his website, but if you need to write down the web address, what's the exact URL for your website?
www.manhattanlaw.com. That's manhattan-law.com. Or you could just type in Chaim Steinberger and you'll probably find me that way.
He's very easy to find. I'm not as easy to find on a website because my website will be relaunching in the middle of June. So I'm doing these videos as a way to get the word out that I'm here. I'm offering my services and happy to speak to clientele. Chaim, those were really brilliant thoughts. It's very, very enjoyable, and I'm truly honored that you took time out of your busy Friday to sit with me and do more than just chat. I feel like we've been actually working. And what I love about the law is the difference between a lawyer at rest and the lawyer at work is, a little sweat. Actually, for a lawyer to work requires thinking like a lawyer and sitting there and parsing ideas. It's almost like a magical process. And suddenly, next thing you know, you sound like a lawyer. And next thing you know, you're putting pen to paper or you're typing a document that is submitted to a decider. And remember, family court, now just to clarify, because Chaim was talking about Supreme Court, family court are cases heard by judges separate and apart from divorce proceedings. They're typically in a different building. I'm upstate now, where I've seen counties where the Supreme Court and family court's all under one roof, and you have one judge who wears multiple hats and goes back and forth between their role as a Supreme Court judge and their role as a family court judge. But those are distinct roles. I think we've said enough for one meeting. We should adjourn and redo this maybe in a couple of months when we both have time. And if there's a demand, look, bottom line, folks, is I don't get the publicity that I'm looking for. And by the way, this is publicity and attorney advertising, unless you click the like button, unless you share it with a friend, unless you follow me on YouTube or on Twitter or whatever other platform that you choose. Chaim's got a dynamite website. Chaim has the Google, what am I trying to say here? Chaim can be located, and he should be, because he's a talented and successful matrimonial attorney. Any parting final words for our audience before I run out of steam here?
And I'll say this: I've got a page on my website titled "The Free New York Divorce Guides," and I have a bunch of material there for people either in family court or matrimonial court, how to pick a lawyer, how to recognize a superior lawyer, how judges decide cases, what to do and how does the process work, what are the standards, what is relevant in child custody. And of course, when we get to best interest, that means everything is relevant, but we'll leave that for another show. So it's always great speaking to a skilled client. You get to compare ideas and contrast and see how do you do things and how. And I've learned a lot from you, Carl, because you have a tremendous experience both in the family court itself at the trial level. So whenever we're at trial, you're talking to a judge at this level, but really you're also talking through the record to the judges at the appellate division who are going to review it. So you're playing sort of like a two-tier chess game, and you have to. So the fact that Carl has so much appellate experience makes him a savvier trial lawyer because he can now set things up. And when you tell the judge, I object, Your Honor, the judge knows that sort of it can always go up on appeal. So having these opportunities to compare ideas with other lawyers, with skilled lawyers, and I get to learn from you, and hopefully we share some of that knowledge with our listeners here today.
Yes, thank you so much for stopping by. I'm going to end the recording and thank my audience for stopping by today, and wish everyone a delightful weekend. Thank you. Take care.